Okay, as we move into this week and we're talking about the judicial branch, we're not going to spend a lot of time talking about Article 3 because Article 3 simply states that Congress shall establish a Supreme Court and such other courts as they shall deem necessary from time to time. That's a paraphrase, but that's essentially all they say, that the court power, the judicial power of the United States shall be vested in a Supreme Court and other courts. Not too much about that. These judges will serve for life during good behavior. And that simply means that unless they're impeached for a high crime or misdemeanor, they serve for life. They'll be appointed by the president and approved by the Senate. But other than that, Article 3 is pretty vague. It doesn't say how many people ought to be on the Supreme Court. Numbers have been as low as 6 and as high as 10. It doesn't say how many federal courts there ought to be. Should there be one in each state, one in each county, one in each township? It doesn't say. It leaves that up to Congress. So, the Supreme Court is established. It is established by the Judiciary Act of 1789, which sets the number of justices and gets the court system going. And what I want to do in this talk, in this lecture, is talk about how the Supreme Court has dealt with things throughout history. First, one of the great debates is the role of the court. That is to say, there are two different views on what the court, and I'm going to talk about the court as the Supreme Court, and we'll just kind of encompass federal courts under them. But what is the role of the Supreme Court? Is the role of the Supreme Court what is called strict constructionist? That is to say, should the men and women on the Supreme Court interpret the Constitution according to the common phrase would be original intent, according to what it meant, what the founders meant at the time? And there are many who say that's what the Supreme Court should do. It should simply determine what the Constitution says and what it means. A second way of looking at things is to say, no, the country has changed over the last 200 years. We don't need to do what the original founders wanted. We ought to be what is called an activist court, which means you interpret the Constitution in the context of the current American political system, the current societal norms. This is a debate that we're not going to resolve right there, but you'll be able to see that as we talk about court cases in this lecture and in one specifically later on in the course about the different court cases that come up under the First Amendment. Well, history of the United States Supreme Court. It kind of breaks into three phases. We're not going to be too specific with these, but in general, in the early years of our country's history, that is to say up through the American Civil War, so for the first 70 or 80 years, the role of the Supreme Court, or its main court cases, dealt with the relationship between the federal government, the national government on the one hand, and state governments. That had to do with national supremacy or states' rights. Here was a fundamental issue being decided at this time. Let's take the word United States, or the phrase the United States. Is that a singular or is that a plural noun? That is to say, is it the United States, a single entity, or is it the United States, a group of many states united? Another way to look at this, once a country or a state like South Carolina joined the Union, they joined voluntarily by ratifying the Constitution. Could they then unjoin the Union? Could they, to use their word, secede? South Carolina would say, well, we voluntarily joined. We have the right to voluntarily withdraw. This was the great debate. Now, the Civil War resolved this in the issue of the federal government being more significant than the state governments. But in the 1820s through the 1860s, this was by no means a done deal. And it manifested itself in many ways. If a state had a law and the national government had a law, which one outweighed the other? Now you might say, well, I thought you said Article 6, the Supremacy Clause said the national government did. Well, that's true, but that wasn't necessarily the way everybody interpreted that. What if there were conflicts over trade, conflicts over contracts that were given out? All of these will wind up being different court cases, and over the course of the first 70 or 80 years of the country, these court cases are increasingly decided in favor of the national government. A key player in this was John Marshall. He is not the first justice of the Supreme Court. There had been a few others before him, but he is a significant Supreme Court Chief Justice. He's Chief Justice from 1801 to 1835, and during those 34 years when he is Chief Justice of the Supreme Court, he will take huge steps towards what is called judicial nationalism. That is to say, using the power of the Supreme Court to increase the power of the national government at the expense of the states. By the time the Civil War is fought over this very issue, whether or not the states have a right to secede, and is resolved the way it is with the North winning, this issue is finished, and the Supreme Court moves into a second phase. And this is the post-Civil War issue, where really the Supreme Court is deciding how to respond to the Industrial Revolution. And what I mean by that is that the Industrial Revolution had changed society in so many ways. It had changed, one of the things that needs to be decided is what is the role of government in terms of this new economic system. Is it the role of government to regulate wages? Is it the role of government to guarantee certain working conditions? Is it the role of government to guarantee certain living conditions? The common theme here is this idea that was very prevalent in the late, now we're in the second half of the 19th century, the late 19th century, called social Darwinism. Charles Darwin, I'm sure you've heard of, writes this book called The Origin of Species and Natural Selection in 1859, and he puts out a theory of evolution, which centers around a couple of themes called natural selection and survival of the fittest. And essentially what that means is that over the course of years, nature selects the fittest of species to survive, and those that are unfit are weeded out, and therefore they get out of the genetic pool, and the fitter animals survive and reproduce, and etc. That's evolution. Well, that was all fine and good for biology, but there were others who said, well, wonder if this applies to other systems. That is to say, I wonder if you can take the notions of Darwinian thought, this idea of survival of the fittest, and apply it to, say, economic systems. So that if one person is able to use their ingenuity or just good luck or whatever it might be to be worth millions of dollars, and somebody else, through making bad decisions or just didn't get the roll of the dice, is starving on the streets, isn't that just nature selecting some people to survive and others to not? And if the government gets involved in this, won't that mess up the system? I mean, after all, this is evolution. This is something that's progressively good. And this is the idea that's being debated. What is the role of government? Shouldn't the government just be, the phrase was laissez-faire, hands off, let things go? Because if it interferes, if it starts saying, well, you ought to pay a minimum wage, or you ought to have a certain hourly rate or working conditions, you shouldn't work 9-year-olds in coal mines, then that's going to mess up the system. These are the kind of court cases that are cases that come before the Supreme Court, cases having to do with what is the role of government in the economy. Well, that lasts until the modern age, which we'll pick up, say, with World War II. In the modern age, the two big issues that the Supreme Court has dealt with since the 1940s on, and deals with still today, are personal liberty and social equality. Court case after court case that we hear about today has to do with things like the right of a woman to terminate a pregnancy, gay marriage, affirmative action. These are all issues that have to do with personal liberty or social equality, and those are the cornerstones of court cases in the modern age. Well, what are some important cases along the way? I want to talk about just a handful, and we're not going to get into a lot of detail because you'll get to do that in your readings. But I want to just highlight a handful of these court cases that have played a key role in shaping the judicial process. And the first one we have to begin with is Marbury versus Madison. This was a court case decided in 1803. And the key element in this is that the Supreme Court declared an act of Congress unconstitutional. John Marshall is the Supreme Court Chief Justice, and he announces, as part of the Supreme Court's decision, that the Judiciary Act of 1789 was unconstitutional. This was the first time that had ever happened. This was the first time the Supreme Court had taken it upon itself to declare an act of Congress unconstitutional. Now, this is a very common thing today. We talk about unconstitutional laws all the time. That is something that is created, if you will, by John Marshall in 1803. It's the process that you will learn as judicial review, the power of the Supreme Court to declare a national law unconstitutional. And eventually this will be used to declare state laws unconstitutional as well. Next court case is McCulloch versus Maryland. This is in 1819. This has to do with something called the Bank of the United States. And the reason this Supreme Court case is important is because the state of Maryland was taxing a branch of the federal bank. They didn't want the federal bank in their town, so they were going to try to tax it out of existence. And in Marshall's wonderful words, the power to tax is the power to destroy. What he decided was that the state cannot pass a law that regulates the federal government. Okay, the state cannot tax an agency of the federal government. In that battle that we talked about between the national government or states' rights, this was a clear victory for the national government. Dred Scott versus Sanford. This is a court case in 1857, and this is the court case that set the Civil War towards its inevitable end. Dred Scott is a slave. He had been taken by his master from his slave state of Missouri to Illinois and then to Minnesota. When his master dies, Dred Scott sues the widow who inherits him for his freedom, claiming that since he'd been taken to live in free territories, he was therefore free. This court case goes all the way to the Supreme Court. If you're wondering how in the world a slave can do that, obviously he had sponsors who were helping him. But this goes all the way to the Supreme Court. In 1857, the Supreme Court says three things. It says, number one, no, Dred Scott, you are not free. Secondly, you're not even allowed to sue because you're not a citizen, you're property. And thirdly, and most importantly, slavery can spread anywhere in the territories. And that particular part of this decision was something that led to the inevitability of the American Civil War, because the tensions that were growing in the 1850s wasn't so much about slavery in the South where it existed. There were a small percentage of the people who wanted to abolish slavery there. The great tension was whether or not slavery could spread west, to spread to the into the territories. And with this announcement in 1857, the Supreme Court is saying Congress cannot make a law to keep slavery from spreading to the territories. And this puts the Civil War on a dead-end course. Well, after the Civil War, slavery is abolished, but that doesn't mean all is well in the South. And in the South, there were different kinds of laws called black codes, which were used to keep these newly freed slaves, the freedmen and women of the South, the African Americans of the South, in as slave-like a condition as possible. And one of the things that they would do is have laws that would segregate the races. In Louisiana, there is a law called the Separate Car Act that had to do with railroad cars, which said that people of African American descent had to be in separate cars. A man named Homer Plessy, who is 1/8 African American, happens to be in the white rail car. He is arrested for that, and his case goes all the way to the Supreme Court. And in the Supreme Court case of Plessy versus Ferguson in 1898, the Supreme Court declared the concept of separate but equal. That is to say, it legalized segregation. As long as equal facilities are provided, whether that is drinking fountains, restrooms, restaurants, churches, schools, anything public, as long as those are provided, you can segregate the races. And this will stay the law of the land, segregation will stay the law of the land until the 1950s, which is the court case we're going to talk about now. In 1954, 13 parents representing 20 students in Kansas sued the Supreme Court under the 14th Amendment. The 14th Amendment had been passed in 1868, and a phrase that you would learn is that it guaranteed equal protection under the law. And these parents representing their students said, our students are not allowed to go to the schools that they want to go to because of segregation. And this goes all the way to the Supreme Court, and in the court case of Brown versus the Topeka Board of Education in 1954, the Supreme Court overturned Plessy Ferguson. It overturned that court case that made segregation legal and desegregated public schools in America. Now, this did not solve the civil rights issues because it actually only led to them because these laws had to be enforced in the South and they weren't, and that's a whole other story that we'll get to. But at least the policy of the Supreme Court, beginning in 1954, was that the notion of segregation, the notion of separate but equal, was invalid at the very face of it. That is simply not a reality in America. 1960s, we get a court case that some of you are probably familiar with through cop shows. The idea of Miranda versus Arizona. This has to do with the rights of the accused. It is one of many court cases in the 1960s, but Ernesto Miranda was arrested for rape in Phoenix. And in the course of his trial, he was never given, he was not told about, I should say, he was not told about certain rights that he had under the Fifth and Sixth Amendments. The Fifth Amendment, of course, guarantees that you cannot be forced to testify against yourself. Well, if you're a police officer, do you have the obligation to tell somebody you're arresting that they have that right? Or is it just simply on them to know their Constitution? Up until this time, the Supreme Court had not really passed a judgment on this saying that they had to, but in the court case of Miranda versus Arizona, it was decided by the Supreme Court that people accused of crimes have to be told about their rights. That is to say, you have to hear what you've heard in all those wonderful cop shows. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to have an attorney. Again, these were all rights that were guaranteed in the Constitution, in the Bill of Rights rather, back in the 1790s. But the issue here was to what extent are accused criminals, people accused of a crime, entitled to know about their rights. And Miranda versus Arizona is simply one of many. Gideon Wainwright is another that had to do with when can you be told? What if you can't afford a lawyer? Should an attorney be provided for you? All of these things are changing in the 1960s as part of a civil rights movement. The last case I want to talk about is Roe v. Wade. This is a court case that takes place in 1973, brought to the Supreme Court in 1973, and it has to do with a woman who appealed the law in Texas which would not allow her to terminate her pregnancy. She claimed the right to privacy. That as a woman, she has the right to privacy, the right to control over her own body, and that this allows her the right to terminate her pregnancy, and that if there's a law in Texas that does not allow her to do this, this law violates her constitutional rights. Court case went all the way to the Supreme Court, and she won her case. And this has remained the law of the land then since the 1970s. And this, along with the Miranda warnings, along with the Brown versus Board of Education case, are examples of the modern day notion of what the Supreme Court deals with, issues of social equality and personal freedom.